Hello and welcome to another episode of Colorado Politicking. I'm your host, Pat Poblete, and this week we are focusing on the news that a jury has decided that DaVita Inc. and its former leader, Kent Thiry, did not illegally restrict competition for DaVita's employees. Now, you may remember, this is a case that we previewed for you with our crack court reporter, Michael Karlik, just a couple of weeks ago. Michael, you were subsequently at the courthouse pretty much every day following this case through to its conclusion. So I'm bringing you back on today so that we can kind of wrap up what we started a couple weeks ago. But before we dive into that too much, I want to start off by having you remind us a little bit of what was at issue in this case, in this trial.
Well, Pat, depending on your point of view, this case was either about whether CEOs can control the job opportunities that their employees have in front of them, or if companies are able to learn about when their key employees are about to be lured away and compete to keep them. Now, the government charged DaVita and Kent Thiry with violations of something called the Sherman Act, which is designed to outlaw anti-competitive behavior in the marketplace. Now, essentially what DaVita did was have these gentlemen's agreements with other companies, competitor companies for employees that had two components. One, those companies would not actively solicit or try to lure away DaVita employees from DaVita, and DaVita employees had to either tell their bosses if they were under consideration for one of those jobs or just be actively looking for jobs other than those three companies. Now, what the government had to prove is that Kent Thiry knowingly entered these agreements with the intent to allocate the market. In other words, instead of competitor companies trying to say, these are my customers and these are your customers, they were in effect saying, these are my employees and these are your employees. It was a very novel interpretation of the Sherman Act. And as you mentioned, after 2 days of deliberation, the jury found that the government hadn't proven its case beyond a reasonable doubt for any of those three agreements.
Michael, why do you think that is? Why is it that you think the jury came back with not guilty?
Well, there were multiple elements to these crimes, any one of which could be grounds to acquit the defendants if the jury simply didn't believe the government had made its case. In two of the agreements, there didn't actually appear to be any consent by Kent Thiry to enter into them. So an agreement needs the agreement of two parties. So it's possible the jury simply thought there wasn't a scheme, a conspiracy with two of those companies. The evidence for the government was a lot stronger with one competitor company called Surgical Care Affiliates. And in fact, that company is part of a separate criminal prosecution in Texas for these exact same non-solicitation agreements. But again, the government faces the same problem of proving intent, knowledge, and then that the agreements were made to end meaningful competition for employees. Now, Pat, I know you know that legal terms are very specific, but they can also be interpreted differently by different parties. And on the first day of jury deliberations, the jury in the DaVita trial asked, what is meaningful competition? Now, the judge did end up giving them an instruction, but that shows that the degree to which these agreements stopped employees from moving between companies, locked them into their jobs at DaVita, was a hot issue in the jury room.
Now, Michael, when we had you on to preview this case a couple of weeks ago, we talked about the potential implications of a guilty verdict. Now, that's not what we got, but are there still implications stemming from the way this trial happened?
I think that it's fair to say that a lot of companies will be wary of these non-solicitation agreements, at least with the exact terms that we saw here. Now, the government was prosecuting this case according to what's called a per se rule, which means they don't have to prove that there was some positive benefit to these agreements. It was just inherently anti-competitive that people did this. It's possible that in other cases, under slightly different circumstances, a different jury would see that these are inherently anti-competitive and there doesn't need to be a justification like business relationships or wanting to compete for employees in order to find that these agreements do in fact violate the law. But at the very least, if they're not illegal, it is distasteful for it to come out in public that CEOs are trying to control the job opportunities that their employees have in front of them. So maybe on that basis alone, companies will be a little more wary of situations that could potentially lead to their emails and text messages being aired in a federal courtroom for 2 weeks straight.
Well, Michael, I want to close out with, I know when you cover something intensely for a period of 2 weeks, there are sometimes some observations that get left on the cutting room floor simply because, you're doing so much coverage, not everything can make it in, right? So I want to get your general perception of the courtroom. What was it like?
Well, Pat, I think the most obvious observation about this particular trial was the jury itself. This was an incredibly savvy group of jurors who were with the government and the defense every single step of the way in this trial. White collar cases can kind of be complex or boring, especially when you're hearing from CEOs, people with their own business language talking about business deals and the way that recruitment is done. But these jurors, through the questions that they posed to witnesses, showed that they really understood what was happening, and they were curious about things that the lawyers didn't even think to ask. I'll give you an example. There was a juror who clued into the fact that DaVita and Thiry had these alleged agreements with 3 companies, all of whom were led by former DaVita employees who Thiry knew personally. Now, when the defense presented its expert witness who analyzed the behavior of all competitor companies in this market, the juror asked, well, is that really the correct comparison? Because it seems that the only demographic of interest was companies founded by former DaVita employees who Thiry knew personally. Now, the expert obviously didn't analyze that, but it's clear to see that jurors were thinking about how is this similar to other cases and how is DaVita different in its behavior in the marketplace. So these were no antitrust experts by any means, but I think they all walked away knowing quite a bit about market competition and the Sherman Act.
Well, Michael, thank you so much for your comprehensive coverage of this case and of really the best coverage in the state of any precedent-setting court decisions that there is. Read Michael on coloradopolitics.com, and you can see him here about once a month. So until next week, where we probably will have a different guest, you'll probably have to find Michael a little bit later in the future. I've been Pat Poblete. Thank you so much for joining us, and we'll see you again soon.